Good afternoon, everyone, and welcome to our first Bank Council Roundtable of 2023. Today's topic is lender liability, refresher and recent case law update. We have recorded today's presentation due to a scheduling conflict, but we will have 15 minutes at the end for Q&A. As a result, we're enabling the chat function, and if you have any questions, please forward them in the chat function. And at the end of the presentation, I will ask those questions of Steve Waterman. Today's presenters are Jamie Whatley, a partner in our Dallas office, who focuses primarily on senior lending, but also works on some mezzanine deals and does some workout work. And Steve Waterman, who, like me, does a little bit of everything, including lending and workouts and anything that has to do with the bankruptcy code or the UCC. At the end of the presentation, Steve will answer the questions that I have, both from myself and from the audience. And with that, we'll start the presentation.
Great, thank you, Tom. Now I'll go over the agenda for the program today. We'll do a short overview of why lender liability is timely discussion for today, the types of claims that lenders can find themselves liable for, the best practices to avoid lender liability at all steps of the engagement, including origination, administration, workout, and foreclosure. And we'll also discuss some recent cases. So why is it timely? Many financial analysts are telling us the economy is shaky. That leads to trouble for borrowers, whether that be a financial covenant default, a payment default, or other defaults that bankers have to engage with their borrowers. Make sure you have good communication with your borrower and don't get your hand slapped for your actions, or subject the institution to lender liability where you're foregoing your loan collections for your bad acts. I'll turn it over to Steve to discuss some of the claims that can be made against the lenders.
Thanks, Jamie. And many of these claims are state-specific law. So this is only a general overview of some of the types of claims that are asserted within the overall lender liability portfolio that plaintiffs have. And first, we talk about those based in contract. Typically, these are just breach of contract claims. That is, what does the contract provide and what is required of the bank? Many of these claims are based upon term sheets. These are usually written and they are contain many of the terms, but many of the lender liability claims are based upon what is not included in the term sheet and what the loan may thereafter provide. Remember that in combination with the payment of an application fee, these term sheets could be binding contract. There are also claims based upon oral commitments. And if there is a claim based upon an oral commitment, prior to even entertaining discussions as to a loan transaction, you should know whether your state has adopted a financial institution statute of frauds provision. Third, you may see lender liability claims based upon the loan agreements themselves. Did the bank do what was required to be done under the loan agreements and within the time frame set forth in the loan agreements? This also applies to whether or not there has been a waiver of contractual obligations. Even if there is non-waiver language in the loan agreements, the courts are split as to whether a claim may be waived under a loan agreement. This may also impact whether or not the plaintiff claims that the bank is enforced from enforcing various provisions. The implied covenant of good faith and fair dealing has been a fertile ground for lender liability claims. This is also contained in part in the Uniform Commercial Code Section 1-201. It is an objective standard that the bank did not act reasonably in accordance with the contract rights. However, most courts have held that you cannot create rights outside of the contract terms. Failure to renew is an implied promise of renewal upon maturity. Failure to advance funds. This is a common claim that a lender failed to provide additional funding to protect or preserve collateral or funds necessary to grow the borrower's business. Failure, and that's both advance funds or to provide additional funding. The improper acceleration or call of a demand note or call of a note for deemed insecurity. Again, this provision ties to UCC 1-309 and is a fairly common claim. Wrongful set-off is typically with respect to accounts held at a bank, and then improper sale or a lack of sale is almost a damned if you do or damned if you don't with respect to the bank's sale of collateral or failure to sell collateral. And we can talk about this later. Oftentimes, if you include provisions as to how a sale may be accomplished in the security agreement, could solve that problem. And then not on this chart, you will also see that there are claims with respect to excessive fees or inadequately described fees. NSF or overdraft fees have been common in this area. The next category of lender liability claims are those based in tort. This is a wider array of claims, mostly because of the types of damages that are possible, especially the potential for punitive damages. These claims are typically that the bank has violated some duty that is independent from the promise made in contract. And one of the defenses that a lender has, of course, is the economic loss doctrine to try and curtail some of these claims. But tort claims typically are those such as duress. The lender has threatened to do something which it has no legal or contractual right to do. Fraud in the inducement. Of course, intent is needed, and bankers must have the intent to induce the fraud. There are some actual fraud claims, although these can be waived if they're specifically done in the loan agreement or barred by the peril evidence rule. Negligence claims are somewhat common. In fact, approximately 2 weeks ago, the Wyoming Supreme Court refused to adopt a new claim for negligent lending. That is, you knew you should not have loaned me the money. Other courts have also rejected that claim, but there must be a duty with respect to a negligence claim. Conversion claims are typically tied to set-off, requires an unlawful dominion over property of the borrower. A breach of fiduciary duty claims, those are typically not within the lender-borrower relationship, but It is very common to see this claim asserted, somewhat an argument for constructive fraud tied to control of the borrower. Interference with contractual relations or prospective business advantage is a common claim. This is where the borrower has contracted with a third party. The bank has knowledge of that agreement, and the bank, outside of its contractual ability, induces the other party to breach their agreement with the borrower. The most common way in which this claim is seen is with respect to credit inquiries. Improper control. Again, this is really a constructive fraud claim. Bank dominion over the management of the business operations. Very common to see asserted with respect to agricultural loans and construction loans. Intentional infliction of emotional distress. This one specifically varies from state to state. It really requires extreme and outrageous or reckless conduct by the bank with an intent to cause harm. Libel, slander, defamation, both there's slander of title claims. There's also defamation claims relating to media comments, often with respect to default or foreclosure. Abuse of process is not as commonly asserted. That is stating that the bank has filed an action, typically to enforce a loan or to foreclose collateral without having a reasonable basis for doing so. Good faith and fair dealing. There is a tort side of this claim, apart from the contract side, typically tied to third-party relations with the borrower. Deepening insolvency has fairly well been put to bed in terms of a claim that is asserted, but based upon the bank creating more debt for the borrower, and that the bank should be responsible for those claims. The third category of claims is really statutorily based. Watch out for the CFPB that often likes to assert these claims. We can go through these a little more rapidly. Usury, however, is a very hot topic in dealing with exported interest rates. You see this with fintech lending, correspondent relationships, and payday lending. There's also the shadow lending, that is rent to own or lease to own type claims in this category. Voidable transfers is the newest name for what folks know as fraudulent conveyances or fraudulent transfers. This applies both in bankruptcy cases and under state law as well. There are not many actual intent to hinder, delay, or defraud creditor claims against banks, but there are a few of those. There are many constructive voidable transfer claims. Those are very common, and those are tied to the insolvency of the borrower, that in administration of a loan, every bank should be monitoring, and that the transfer involved less than reasonably equivalent value. Bankruptcy preferences, typically these are with respect to the 90-day period prior to the filing of bankruptcy. And then there are the bankruptcy claims of substantive consolidation, alter ego, piercing the corporate veil, or equitable subordination. These all involve domination or control by the borrower that perpetuates an injustice or fraud causing injury to other creditors, or equitable subordination. that a claim can be recharacterized as equity or subordinated to other creditors. These last groups, RICO, Environmental, Anti-Tying Act, taxes, securities law, and employment liabilities all pop up in connection with lender liability claims that may be asserted against a lender, and there are cases that deal with all of these. And with that, I'll turn it back to you, Jamie.
Great, thanks, Steve. Now that Steve has talked to us about the types of claims that the lenders need to be concerned about, we're now going to discuss when those claims can arise. At the beginning, when you're first developing a relationship with a potential borrower, that's in the marketing phase, the origination, and the application or approval process. In the middle phase is when you're administrating the loan. Does the borrower need a waiver? Do they need some accommodation? Do they need an acquisition that may not have been permitted? Or has a default occurred? At the end, unfortunately, if you've not collected the loan proceeds, you could be looking at a distress situation, a workout, or foreclosure, or a bankruptcy. We're now going to go through best practices at each one of these phases that you can implement with your bankers. The first is how to minimize claims at the loan origination stage. Remember who you are. The lender is the one who wants to get repaid on the loan. The borrower is the one who wants a successful business. Lenders oftentimes mix up what their role is and want to help the borrower be successful in their business, and that's really not their role. So stay true to your role. Make sure that you have set policies and procedures for the type of communications at each level that can be done by the bankers. Realize that you have a duty of reasonable care and to act without delay. So what this means is if a potential borrower has requested that you close a loan by a certain date, don't make promises that approval will come through and be timely if you do. Getting back to a borrower 6 months later on whether or not a loan will be approved is just not very timely. Train those who deal with the borrowers on these policies and procedures so that everybody is taking a consistent approach within the organization. Document deviations very well. You have a duty to negotiate the loan documents in good faith. So if you have a term sheet, don't try to sneak better terms in because a borrower is not paying attention. That's not going to look well if there's a later issue with that. Make sure to document all deviations from bank policies or term sheet changes so that you have a file of why those changes were made. Know whether or not the state in which the loan is being negotiated has a statute of fraud so that you can add in a provision that the borrower cannot rely on oral statements and that the loan documents are the controlling portion. If you don't have a commitment, do not promise that the approval is going to take place. Oftentimes, a borrower may see a loan agreement come across an email and presume because they've received the loan agreement that there's now a commitment or that the bank has approval. And that may not be the case at all. So always circulate that as a discussion draft. Know what's in your commitment letter if you do have a commitment. Sometimes there may not be a diligence out and a material diligence item has arisen. If that acquisition is ready to close and the commitment papers say that you're bound to close, know that you're going to be funding that loan. Make sure all emails are professional. We're going to discuss a case in a little bit about where the email communication to the borrower looked very different than the story that the email communication to the bank looked. And those can be discoverable, and that did not look good to the court. So always practice good decision-making at the loan origination stage. How to minimize claims at the loan administration phase. 1, audit the loan file and make sure the file is complete and gives the full picture. If there's been a lot of meetings or oral discussions with the borrower, make sure that you followed up with an email paper to the trail of what was discussed. Make sure you understand the loan documents. Oftentimes the loan gets documented and there's not been issues for several years. And the banker may not be aware of what's required under that particular loan agreement with respect to that they need to send notices of default. If they're going to sweep accounts, the notice must be provided. Don't take action unless the notices have been complied with under the loan documents. If you do have a default, make sure to notice it. Don't just address those orally. Oh, we'll waive that. Don't worry about it. Don't create some kind of course of dealing by your communication or email. Make sure it's documented. Avoid, if there are defaults and you're very concerned about how the borrower is operating, avoid controlling the operation of the business of the borrower. Avoid choosing the management team and avoid controlling the board. Now, what that means is maybe the CFO or the CEO is not doing a good job. It's okay to raise that concern, but what you don't want to do is suggest that the borrower fire that particular individual and hire somebody that you may know that might be good for the role. What we would do in that circumstance is recommend a chief restructuring officer to make that analysis himself and appoint the particular person that he thinks is good. Always give the borrower an option of 3 different chief restructuring officers. It's okay for the lender to have board representation, but you don't want to control the board. So make sure that you're an active participant, but not controlling the board. And avoid control of operations of business. Telling the borrower, who to pay or working directly with the suppliers. And what we mean by that is deal with the borrower. You're making the loan to the borrower. Let the borrower decide which creditors to pay and what promises to make to suppliers. Make sure you have a policy on communication with third parties and don't interfere with the borrower's contractual relation. When you're very involved in the administration of the loan, make sure you're documenting why. This particular CFO is having issues. This management team is having issues. We're involved with the borrower because X or Y. And that way there's a good reason in the file that explains why you're being involved with this particular borrower. I'm going to turn it over to Steve for how to minimize claims at the loan collection phase.
Well, again, the comment, remember who you are. You are not the friend of the borrower. Your obligation is to protect the bank and to collect on the loan so that the bank can obtain repayment of the loan. You are not to control the business. When the folks in the special assets department first get the file, they should take a fresh look at the loan documents. They should verify that perfection of security interest has occurred. They should examine the course of dealing that has happened during loan administration. Have modification or waivers of contractual forms been documented? Is it possible the bank could be stopped from enforcing various terms because there have been informal or undocumented waivers? There should be an analysis of whether or not there are potential claims against the bank. These are all problems that can be cured through the use of a modification or forbearance agreement, but you should certainly be aware of them. Be careful with respect to non-monetary defaults. Non-monetary defaults oftentimes raise problems for the bank. And these include those with respect to deemed insecurity or demand obligations. Provide lots of notice. Notice often becomes a problem and a source for lender liability claims. So you should have the ability to document these in a forbearance or modification or extension agreement of some kind. Remember that there's safety in numbers. Meetings with the borrowers should have at least 2 bank representatives. This avoids the problem of he said, she said, because you've got an extra witness available from the bank side. Special assets should certainly not take control of the borrower or determine which of the borrower's creditors should get paid. Do not make any business decisions for the borrower. And business decisions could include things such as marketing, purchasing, locations of operations, acquisitions. Any of these things could be construed as the bank controlling the debtor's operations. Emails can be construed as written commitments, and you should know whether or not in your state you have a financial institution statute of frauds, but you should certainly be wary of emails. Again, they should be professional and they should be formal. They should, too many times, we all think that email communication is less formal, yet it is email communication that is scoured through in the course of discovery in lender liability cases. And don't have knee-jerk reactions. Do not act precipitously. You need to know the facts first. So when the man in the disgruntled marriage arrives at home and says, if I won the lottery, what would you do? And his wife says, I'd divorce you and take half of the winnings. And he says, here's your $20. So do not act precipitously. Make certain that you know what the facts are before you engage in default or enforcement actions. This next slide really shows that there is a direct relationship between how factually involved a lender is in a borrower's business and your potential for lender liability claims to be asserted against the bank. That's not necessarily success on the merits, but you need to remember that there is a direct correlation as to whether or not you will be sued. And we all know that the filing of the suit itself ends up with a great expense for the bank. Jamie?
Great. Now we'll examine some recent cases from 2021 and 2022. The first is Bailey Tool versus Republic Business Credit. In this particular case, we find that while lender liability is rare, it can happen under egregious facts. In this situation, the borrower was told by his existing lender that it needed to find a new lender relationship. In working with Republic Business Credit, one of the things the borrower made clear is they needed a 90% advance rate with respect to their factoring and inventory loan. The bank promised the borrower, this is a strong deal. We'll get this done with a 90% advance rate. And there is very strong documentation showing that that was the communication via email by the bank to this prospective borrower. The problem was internally, the communications between the bank and its officers looked very different. The email said, this is a very risky deal. Even if we go with a 90% advance rate, there's several customers that we're very concerned about, and we may need to make those ineligible or change the advance rate. Well, sure enough, the loan closes, and shortly after the closing, the bank decides it's insecure. And what does it do? It doesn't lend at 90%. In fact, it makes the one account receivable that the borrower was very concerned about, that it was dependent upon making the loan right, basically ineligible. With no real rationale and no changes in facts about that particular account debtor status. The bank then argued that, well, you should have looked at the portal. We made all of the information as to why we made that particular account ineligible available on this portal. When it was examined about how the portal worked, it was basically incomprehensible to the borrower as to why it was made ineligible. To make matters worse, the bank then took complete control of the cash, but not only the cash, the disbursements. So what happened is they were telling the borrower who to pay, when to pay, and why. Not only that, they then replaced the entire management team and were very controlling of all aspects of management. The bottom line is these emails were discoverable as well as all the actions. And as a result, the court determined the lender breached its contractual agreements and the lender breached its good faith and fair dealing towards the borrower. The court also found that the lender engaged in lender liability. Even though a fiduciary duty never arose, the court concluded that the lender committed fraud and misrepresented it was over advanced or insecure, and also found that the lender tortiously interfered with the borrower's customers and ultimately drove those customers away. And they went so far as to say Bailey would not have had to file bankruptcy and had its enterprise value destroyed, but for the acts of the lenders. Well, you can tell this is bad, and ultimately damages were substantial, which included lost profits, punitive damages, and exemplary damages. And so while lender liability may be rare, it can be very substantial in terms of damages under these egregious facts.
The facts of that case were extremely egregious, and everyone should read that case to know what they should not do as a lender.
Exactly. Steve went through many of those tips, and many of the things that happened in the Bailey case are what he recommended against. The next three cases really are lender favorable. One involved a bakery, and a loan was made by another bakery who happened to be, I guess you would say, one of the largest distributors of the Swedish bakery. And the Swedish bakery was struggling, and so the distributor made a sizable loan in order to try to help turn the business around. And what the court held there is the exercise of control, or kind of helping the borrower establish better procedures. The exercise of control over this particular debtor alone was not sufficient to find lender liability. The lender must also assume a special relationship similar to that of a principal and agent, or the relationship among partners. So in this case, the court was very favorable to the lender, recognizing that the bakery was really struggling, the distributor was truly trying to help, and it just didn't work out. And ultimately, the U.S. bakery had to foreclose on its loan. The next two cases go to directly what Steve recommended in a forbearance agreement. Make sure, and in waivers, make sure you're getting a release of claim for the lender. If the lender is going to assist the borrower in making some kind of accommodation, or if they're going to forbear from exercising their rights, you want to make sure a release of claim is obtained. And you'll find that in both the Twinford case and the Lockford case, both of these in 2021, did just that, practice good loan procedures, but both involved the necessary waivers and forbearance agreements. And in each one of these, there was a clear release of claims against the bank. In both cases, the borrower argued that, well, we were under economic duress, our performance wasn't strong, and that is the only reason that we entered into the forbearance agreement in the first instance. And the court said no. The lender was providing an accommodation. You accepted and signed a forbearance agreement with a strong release provision. And so even when these cases went up on appeal, the court reaffirmed the lower court holding that the releases barred the claims. In the Lockwood case, What was really interesting is in order to enter into a forbearance agreement, they actually got the owner to sign a guarantee. And they basically said, look, we're not going to forbear on these claims unless you provide a personal guarantee. Well, of course, the loans go bad and the guarantor again argues, well, I only agreed to a guarantee because the company was under economic duress. And this, was fraudulently induced to provide the guarantee. But the court said no and ultimately allowed the lender to go after the personal guarantee. So I think, again, when documenting waivers and forbearance agreements, make sure you get the release, because these two cases were very, favorable for the lender as a result of good practice. Steve, do you have anything further to add?
Well, I think that if there is a common practice, every time there is any kind of a loan modification, anytime there is an payment extension, that these should be documented and include releases. There should be a common practice that the borrower is accustomed to executing releases throughout the relationship, and the bank should always get that consideration of the release at each stage. This is especially true with respect to ag lending and construction lending. Every time there are interim payments or advances made, there should be a release that the bank obtains. And I say ag loans and construction loans because those are two situations that seem to be very or more common to have lender liability claims arise.
Steve, do you have any practical advice to give on the operation administration of construction loans?
Well, one of the problems that arises in construction loans is whether or not the bank is exercising too much control over the borrower. In particular, most construction loans will have oversight of the project by an independent project manager who determines whether or not work has been performed and how far the construction loan has progressed in order to determine advances that are to be made. And it should be clear in both the loan agreement and in each draw request that having the lender use that independent project monitor is solely for the lender's benefit. You don't want that to be viewed as control. And so you want the project management monitor to be part of the loan agreement, and that it is for the lender's benefit in determining that the project is advancing and whether or not the advance can be made for the work performed. If that is done properly, then there will not be control liability or responsibility placed upon the lender, because you are not actually controlling the project, but only monitoring the project. And within the last 10, 15 years, there is a good 10th Circuit decision that actually keeps the bank from having liability for control by properly documenting the monitoring that is taking place. Similarly, with respect to ag loans, a lot of times the bank will try to help the borrower. And we need to remember the old adage, no good deed goes unpunished. A lot of times the bank will even help them prepare their financials or to type them up so that they are more presentable. The bank needs to be very careful with respect to those. Many of these loans are renewable terms. or annual terms, and the bank will not provide sufficient notice in advance that there will not be a renewal, just waiting until the last minute. Proper notice should be given by the bank to the borrower in the event a loan is not going to be renewed. One question I have for you, Jamie, is with respect to drafting security agreements. Oftentimes, we use standard loan documentation and security agreements, and we don't contemplate at the outset how collateral that is being provided might need to be sold, or whether it is in a specialized industry. Do you ever draft terms of security agreements that provide for different types of sales or the manner in which property will be sold?
Absolutely. I think one of the things that we recommend to our clients is, one, what is the material collateral and what's the exit strategy? Because if the bank knows what the exit strategy is, if the loan doesn't go well, that is whether they're going to foreclose on the stock or whether they're going to sell this special type of collateral, whether that's vehicles or real estate or whatever it may be. If they know their exit strategy, then we can document and make sure that we've looked at state law to look at that. And oftentimes that can arise with respect to exercising under the pledge. Do they have the proxies required by the applicable state in which they're incorporated to remove the board and to step in at the board level? So I think those are all important considerations, is to make sure that the bankers know their exit strategy, not that they're just trying to close the deal.
I think that's a very important point because in many circumstances, if there's more forethought at the inception of the loan, it will resolve problems at the end of the loan in terms of liquidation of collateral. Absolutely.
Well, I think we've learned about the types of claims that Steve kind of taught us, and then we know when those can arise. We've tried to run through what the best practices to avoid any of those claims are, but I know the audience may have some Q&A that they would like to ask, so I'll pass that back over to Tom and Steve to address some of those questions.
All right. Well, we got a question from the audience. I'm going to lead off with that one. From Gary Katz, we have the question, for lenders like me who are inclined to try to help their borrower, can you give us a few more examples, like the one you gave about banks helping to make borrowers' financials presentable, where no good deed goes unpunished?
So do we want examples of cases that went bad, or do we want examples of good practices here?
I think the request is for an example of cases where the lender got held liable because they had tried to help the borrower.
So I think the most important thing to understand here is it is a spectrum. As the graph showed, the more factually involved you become, the greater chance there is of a lender liability case being filed. It does not mean that you can never comment or approve, or you can have a borrower ask whether they should follow plan A or plan B, or if the banker has had experience with one or the other and has some insight. Providing insight is fine. It's just as you move along the spectrum, more and more control means a greater likelihood of a suit being filed.
Follow-up question to that, also from Gary. His fund has staff, turnaround and workout experts who give advice to borrowers when asked. And they know it's a potential problem, and they get the borrowers to sign waivers and non-reliance letters, et cetera. But is that sufficient, or is there more they can do to avoid liability when they have staff advising their borrowers?
Well, obviously, you're following a good practice in obtaining releases, non-reliance. And oftentimes you will see in the private equity world where you will have an equity participant who is also a lender and may sit on the board but does not control the board. You really have to steer away from when sole reliance is upon the lender, or that it is only the lender who is controlling all of the operations. Again, it's where are you on that spectrum? You know, there's everything from no advice to complete control, and where you are determines how a court will determine a lender liability claim.
And I have one other thought on that topic, and that is where it's economically feasible for the transaction, it's better to have a third party come in and provide that advice rather than have somebody from the lender do it. If you bring in a third party, you avoid all of the potential for this being used against you in subsequent litigation. Now, obviously, as with the CRO, you want to provide alternatives. You don't want to say you have to hire Joe Blow to be your third party advisor. Otherwise, you're right back in the soup.
And just broadly, lender liability claims really, the 70s, 80s, early 90s, you had a ton of lender liability claims. Then the number of lender liability cases decreased, but so did the activity of the lenders in controlling borrowers decrease because of those lender liability cases. So are there cases where lenders have been responsible? Yes, a lot of those cases come from the 1980s. And the case that we provided is a good case for everyone to read, because it is all of the things that you should not be doing. So take a look at the Bailey Tool case. It contains what you shouldn't be doing. It is the case that has made everyone around the country say, I guess lender liability is not dead.
Next question comes from Joel Steiner. Hi, Joel. And the question is, what risks are there in charging the default rate for non-monetary defaults?
Yeah, the issue there is not necessarily the default rate. It's more to do with enforcement of non-monetary defaults. How clear that default may be is the greatest factor, because deemed insecurity or calling a demand note with no notice, no forewarning, especially in light of other statements that are made, is the biggest problem with non-monetary defaults. If you have a good record where the default has not been waived in the past, or if it was always documented with the express provision that the bank intended for the borrower to keep that covenant moving forward, then it's not as much of a problem. So it's more with respect to the non-monetary defaults than it is with respect to the rate charged. but charging the default rate is what gets the borrower's attention.
The next question comes from Terry Lenz. When lenders get 13-week cash flow forecasts, as they generally do in workout situations, the borrowers typically show who they will pay and who they won't pay. What are the risks for the lender in looking at those and providing feedback on a 13-week cash flow? That, you know, where's the line between looking out for your own interests and telling them and controlling the borrower and thus running into liability?
Hi, Terry. Good to hear from you. There is a difference between having knowledge of what is being paid and controlling who shall be paid. So you may have knowledge. I have been involved in a case where the borrower alleged that because the bank had the DDA, that the bank manager was sitting in his office reading all of the checks. And so the bank officer, branch manager, knew who was being paid and how much they were being paid, and even read all of the memo lines. One, that's not reality, and two, that is not control. Control requires the bank actively taking part in the decision as to who shall be paid.
All right. The next question goes back to the subject of remedies, and it has to do with how the recommendation that you provide for your remedies in the contract works under Article 9 of the Uniform Commercial Code.
Oh, okay. So I'll refer to Article 9, the official version. Of course, all of the Uniform Commercial Code is enacted in each individual state, and there may be state variations. But and I don't think anyone's varied on this. Section 627 of Article 9 of the UCC requires that when you are selling personal property collateral, that the sale be conducted in a commercially reasonable manner. And that means in conformity with commercial reasonable practices of dealers in that type of collateral. And there are three options, but essentially you only have one, 9627B3. That being said, Article 9 also permits the secured party and the borrower to agree upon the standard by which you measure that commercial practice, provided it's not manifestly unreasonable. So what is manifestly unreasonable is to be determined by the courts, but certainly it has to be that you are finding or determining what the remedy will be in good faith. Article 1, Section 304 of the Commercial Code has a good faith requirement in all commercial dealings, and good faith as defined in Article 1 is honesty in fact, observing reasonable commercial standards of fair dealing. So if you provide the detail in the security agreement as to what the standard for the sale of that collateral will be, those will most likely be upheld and enforced by the courts. This is not a problem with common collateral. It's more of a problem with one-off collateral a more sophisticated collateral or unusual collateral. It's much different to sell the repossessed Ford Escort than, it's easier to sell the Ford Escort than it is to sell a Lamborghini Murcielago. Just because of the disparity of the prices of those two vehicles. So you should, in the security agreement, you can outline what the standard will be for selling the Lamborghini. Like Jamie said, you have to know your exit strategy up front. So how are you going to sell that collateral? You can agree on the standard. And it's interesting to hear borrowers and their responses to those provisions, because they may say this is a better way to sell it. And if you can demonstrate that those provisions are actively negotiated, you have a much greater likelihood of prevailing, provided you actually comply with your agreement and what the standard is that you have established.
Follow-up question on that issue, Steve. One of the things that I've done in the mortgage warehouse context is add a provision to the security agreement that has the borrower acknowledge that the collateral is of a type that is sold on a recognized market. Is that kind of provision enforceable? And how does that play in with what you described here about making sure that you have the appropriate remedies?
So 9627B3 is what I was talking about in terms of reasonable commercial practices among dealers in the type of collateral. 9627B1, or it may be B2, provides for sales on recognized markets. At this point, the only real markets that are held by the courts as recognized markets are the securities markets. And so there may be an active number of buyers of mortgages in the marketplace. I'm not certain that qualifies as a recognized market. So although you have that in there, I think that probably helps the court make that determination, but I would back it up with specifics as well.
Can a lender accept a payment and then proceed to exercise remedies?
Usually no. The short answer is no. And if you've already notified the borrower of a default, and I'm assuming in this case it's a financial payment default, if you accept the payment thereafter, then that cures the default. At least that's in most jurisdictions. And that is common for lender liability claims to be based upon that situation. So if you've accelerated the loan, unless it's being paid in full, typically you would not accept payments.
Final question. Could you talk a little more about the statute of frauds that you mentioned in the presentation?
Oh, I believe mentioned it as a lender statute of frauds provision. Most states have enacted one of these provisions. It may be separate from the statute of frauds generally, or it may be incorporated in your state statute with the other statute of frauds. Usually these are specifically with respect to financial institutions. So you have to fit within the definition of financial institution within the state. But generally speaking, that statute of frauds will invalidate any oral agreement with respect to lending or credit or financial accommodations. It would not apply to other products offered by a financial institution, but with respect to the lending arena, those oral statements are not enforceable.
Steve, final question. This is a follow-up. Is an email a writing for purpose of these statutes?
It may be, yes. Yeah. You've got to be very, very careful with emails. Again, the advice with respect to emails is make them formal. Don't let them be informal. Be careful what you are promising, what you are saying.
Thank you. Thanks everyone for joining us this afternoon. And we'll be reconvening next month where we're going to discuss some of the things the Securities and Exchange Commission is up to, which impact the banking industry.